There are two major types of law questions: essay questions and problem questions. Law essay questions require you to write an essay, unlike problem questions that require you to advise the parties in a scenario. Law examinations tend to contain a mixture of essay questions and problem questions. Tackling each of these questions involves slightly different skills. This is not usually a right or wrong answer. What matters is that you show you know what type of issues you are being asked about. Generally, essay questions are likely to ask you to discuss, criticize, or evaluate or examine. You simply need to produce a good range of factual and critical material in order to do this. Please do not reproduce large chunks of lecture note. The examiner will want to see evidence that you understand the topic you are writing about. You will get very few marks for simply writing all you know about a topic with no attempt to address the issues raised in the questions. If you can adopt or cite the material that you have read on the subject, you will do well. Under the pressure of time, you feel to start writing immediately, but 5 minutes spent planning each essay questions is well worth spending. It may mean that you write less overall, but quality of your answer will almost be better. The plan you need not be elaborate, just jot down everything you feel is relevant to the answer, including case names and sections of the enactment, and then organize the material into logical order appropriate to the questions asked. You should always start the essay questions with an introduction which sets out what you intend to cover in the essay. Very few essay questions require merely facts descriptions of what the law is. For example, discuss the provisions of Selvakkunapalan preemption ordinance. Mostly you are required to analyze the factual content in some way, usually highlighting any problem or gaps in the law and suggesting possible reforms. For example, the provisions of labor laws are in favor of employees. Critically analyze the statement. Where a question uses the word critically, as in critically describe or critically evaluate, the examiners are merely drawing your attention to the fact that your approach should be analytical and not merely descriptive. You are not obliged to criticize every provision you described. Even if you do not agree with a particular criticism that you have read, you should still discuss them and say why you don't think they are valid. However you are knowledgeable in the topic, you will gain higher marks if you structure it well. You should try to learn your material in a logical order. It is not good enough to repeat the question, turning it into a statement for the conclusion. Your conclusion will summarize the arguments that you have developed during the course of your essay. Now, there is an example done for you. All the trust, whether or not they have to satisfy writing requirements, must be sufficiently certain in order to enforceable. Now here, the issue is not that matter in writing, but it is in relation to the reasonable certainty. When you see the downward, discuss the reasonable certainty of the matter specified in section 6 of the trust ordinance with reference to the decided cases. When you see here, section 5 may be discussed, not shall be, may be discussed briefly I think it should not go more than 4 lines. Then here I mentioned that night versus night case and section 6 should be discussed. Then further we will go down and see here. This is also another essential part that you have to incorporate into your essay. The use of words trustee or trust is not essential to create the trust. This is something in relation to the precatory words that we have seen. Even there are some illustrations given to section 6. Now here we are going little bit deep in the topic or body of the structure. Now we have found that there are some items, there are certain matters, there are matters should be certain, such as intention of the author of the trust, purpose of the trust, beneficiary and trust property. You must cite at least 2 cases for each and every item given here. For example, I have given 5 cases for intention of author of the trust, but if you cite at least 2 cases, that's enough. Then the purpose of the trust. When you discuss the purpose of the trust, don't go to the illegal trust matter, but you restrict yourself to section 4. To explain, the purpose should be clear. Then the beneficiary, the well-known case, Anthony Gaspar case that you must cite, and the Kandasamy case also, that is one of the important cases. Then go to the final matter here, trust property. In the trust property, the subject matter of the trust must be a property transferable to the beneficiary. Then the property, we are little bit to explain what is trust property, what is the subject matter of the trust. Then go to, there are so many cases I have given in my PowerPoint presentation. Then here you can cite at least 2 cases, and also you must cite section 8 also. Finally, you must come to the conclusion. Conclusion, as I mentioned earlier, don't summarize what is in the question. Then you must summarize from your argument, whatever you have submitted, then come to the conclusion. That is the end of essay questions. Thank you for watching.